I heard you mention a few minutes ago in response to some of the questions asked by Senator Grassley that it's the president's preference to work with Congress, and that wherever possible he'd like to get Congress to agree with him to pass legislation that he would like. But, of course, the other side of that coin is something that the president referred to repeatedly last night in his State of the Union address, which is that if he can't get Congress to act, he'll go it alone. If Congress won't act the way he wants Congress to act, then he'll issue an executive order anytime he gets the chance. This brings to mind a concern that I've had as to whether or not sufficient analysis is being undertaken when these executive orders are issued. As you know, the Supreme Court has, since Youngstown Cheatham Tube versus Sawyer, and Justice Jackson's concurrence, and certainly since Dames and Moore versus Regan, when that Jackson concurrence was adopted by the majority of the court, it has tended to separate out executive orders into three categories. In category one, you have a situation where Congress acts pursuant to authorization by Congress. And that's where his authority to act with an executive order is at its strongest. Category two is where you have the president acting in the absence of either a congressional authorization or a congressional prohibition. Justice Jackson described this as sort of a twilight zone where it's a little unclear, it's a little murky. Category three is where you have the president taking measures that are incompatible with congressional command. And so I would ask, number one, is this analysis undertaken each time the president issues an executive order? And number two, what was that kind of analysis undertaken when the president, for example, announced on July 2nd of 2013 that he would not be enforcing the employer mandate of the Affordable Care Act throughout the duration of 2014, even though by law the employer mandate was set to take effect as of January 1st, 2014?
Before the president exercises the executive authority that he discussed last evening, and again, I want to preface that with, I think, the pretty clear indication from the president that he wants to work with Congress on behalf of the American people. In the absence of that kind of activity, as he's done with regard to raising of the minimum wage, he's used his executive authority to, will use the executive authority to raise the minimum wage for those who do business with the federal government. Those kinds of activities by the president are done after consultation with the Justice Department, and an analysis is done to make sure that the president is acting in an appropriate and a constitutional way. And those three categories that you talk about, that we all studied in law school from Justice Jackson, are among the things that obviously are a part of the analysis. Where the president's authority is greatest, that twilight zone, and then where the president's authority is weakest.
So in which of those three categories would you put the president's decision to delay the enforcement of the employer mandate? Is that category 1, 2, or 3?
Yeah, I'll be honest with you, I have not seen, I don't remember looking at or haven't seen the analysis in some time, so I'm not sure where along the spectrum that would come.
How about the executive order that he proposed last night with regard to minimum wage? Would that be category 1, category 2, or category 3?
Well, again, without having delved into this to any great degree, that was...
But you're the Attorney General. I assume he consulted you.
Well, there have been consultations done with the Justice Department. From my perspective, I think that would put us in category 1, given the congressional involvement in the matter, the ability of the president to regulate things that involve the executive branch and how contracting is done. It seems to me that the president is probably at the height of his constitutional power in that regard, with regard to the one we're now discussing.
So you're saying there is a federal statute that authorizes him to issue the executive order regarding the minimum wage?
No, I think that there's a constitutional basis for it, and given what the president's responsibility is in running the executive branch, I think that there is an inherent power there for him to act in the way that he has.
And with regard to the employer mandate?
Again, as I said, I've not had a chance to look at it for some time exactly what the analysis was there, so I'm not sure that I would be able to put it in what category. But again, I would think that given that we're talking about a statute passed by Congress that, that delegates, devolves to the executive branch a certain authorities, I would think that you're probably in category 1 there as well. But again, I've not looked at the analysis in some time.
Okay, I appreciate your candor on that, and I see my time's expired, but as I conclude, I'd just like to point out that this is very, very important, and it's one of the reasons why, as one of my colleagues suggested earlier, it could be very helpful for you to release legal analysis produced by the Office of Legal Counsel or whoever is advising the President on these issues. It's imperative within our constitutional system that we not allow too much authority to be accumulated in one person. And it's one of the reasons why we have a constitution is to protect us against the excessive accumulation of power. And I think the President certainly owes it to the American people, and you owe it to the President as his Attorney General, to make sure that when he does act by executive order, that he do so clearly and clearly state the basis of his authority so that the American people can be aware of what's happening and on what basis he's claiming that authority. I look forward to hearing your explanation. Perhaps you can submit something to us in writing after this hearing about his basis for making some of these decisions, particularly with regard to the delay of the employer mandate. Thank you.